Well, we'll go ahead and get started. I know we have some here for estate planning, some here for probate and estate, and we'll go over that as best I can tonight. And glad you're here. And anytime you have any questions, just unmute and ask me, or you can send a, you can put it in a little message box. And let's see if I can get. And what we're trying to do is just talk about probate court overview. A lot of people are always looking for the probation officer. We have little to do with that, more with estate planning and probate process. Is sort of what we deal with. Touch a little bit on elder law, mental illness and alcohol and drug affects all of our families. And I'll talk about the civil commitment process and some points to ponder and some trivia. And again, here's sort of a recap of our topics. We'll focus primarily on estate planning and estate administration, the last one there. And here's a good little overview of our court. And if you know some people looking for a job, we've got a couple of job openings on there even. Anyway, on our estate division, if you look to the left there, we have 5 estate clerks, and they help families from beginning to end. If you look at the ending case number of your case file, like Tina Grooms will have all cases ending in 0 and 5. Sharon will have 1 and 6, so on. So you can always figure out who your estate clerk is and go directly to them. Commitment division, we do involuntary commitments for alcohol and drug and mental illness. We do about 1,800 of those a year. On the estate side, we probate about 2,200, 2,300 estates. Guardianship and conservatorship, we really want to have none of those, but we have about 1,000 of them. And that's helping people that have not done their estate planning. Guardianship is of the person. Conservatorship is of the money. And then I have 4 problem-solving courses that I started, and we'll go through those. And then on the happy side, we have the marriage licenses. And we do about nearly 7,000 last year. And I'll show you our love program. And we'll go from there. I'm going to mute everybody. If you want to unmute at any time, just do that and ask a question. And we've got the staff too of financial, and then also with our law clerks. And I know Jamie has sent this out to you. It's our way to contact our staff. And I grew up in Collins department store with customer service. And what we want to do is be able to get you directly to whoever you need to talk to. If you ever need to call me, you'll see my direct dial number there, and also my cell, and then also my email address. We do have many of our staff work from home some, and so you'll see that they have a cell number, and of course they always can check their email. Any questions on what I'm showing you so far? We're located down at the Four Corners of Law. We've got, we're in the historic courthouse, which is in the bottom right. I'm coming to you from the brick building on the far bottom right, where the Holy City didn't want a big tall building here. So we're in 2 different buildings. The estate division is in the historic courthouse, and our commitment division is at 100 Broad, the recess building. Four Corners of Law, we got City Hall. We've got the state courthouse, which is the also where our state division is, and then the federal law by the federal courthouse and post office, and then the highest law, which is the church. When we do these in person, we give away candy bars. And anybody guess who named it the Four Corners of Law? Who named it the Four Corners of Law? Believe it or not, it was Robert Ripley. It was no great legal historian, just Robert Ripley. Then and now, it used to be the state capitol before it moved to Columbia. It's been redone. It was done by an Irish architect by the name of James Hoban. He did our courthouse and also did the White House and modeled it after the Parliament building in Dublin. Here we are dedicating a monument in his hometown, and that's my son Joseph. Our luggage didn't make it over there, so we had to buy some pants there. Again, we're in 2 different buildings. I'm coming to you from the building on the right. And another trivia question: what's the highest basketball court in the land? I just saw Coach Kelsey may be signing a big contract. I gotta ask him if he knows what the highest basketball court in the land is. Anybody take a guess? We should give a candy bar away. It would be the U.S. Supreme Court. Above the U.S. Supreme Court, there's a basketball gym. I got up there on a tour, made 2 shots, and I've since retired from shooting hoops at the Supreme Court. This was my mentor, Morris Rosen, and also Jamie Robinson, who's on here. We worked for him about 30 years ago. Southern gentleman that treated everyone with great respect, whether it was the janitor or the judge. Estate planning, this is why many of you have joined us tonight. And we don't want your will to look like this. This actually was a will, and we put in some names there, and it had 2 witnesses. And on the right there looks like my Costco list, and then they ended up doing a will. So we never know when God's going to call us, and we want to make sure that we are prepared. And to be prepared, we would offer that you should consider these 11 items or documents. The first that I would mention, we always want to start with a checklist or questionnaire, and we want to go to an attorney. And once we do the checklist or questionnaire, we would list out all of our assets. And we want to learn a few concepts tonight. One is the concept of probate and non-probate property. Probate property is controlled by the will or by the intestacy statute if you don't have a will. And then non-probate property is controlled by a third-party contract, such as joint account with right of survivorship, a insurance policy where you designate a beneficiary, so on and so forth. Okay. Anyway, that's an estate planning checklist. Most attorneys would call it a checklist or questionnaire. They'll have you fill it out. Important to look at your source documents, because many times we may think we have an account set up a certain way, and then we look at it, it's actually a different way. Number 2 there, we've got last will and testament with a trust. Strongly recommend, well, everybody should have a will and everybody should have a trust. If we look at number 6, so there's 2 ways to do it. In your lifetime, you can go ahead and put everything in your trust, and it would be a revocable living trust. That way it would manage your assets during your lifetime, and then at death, it would act as a will substitute. Of course, the attorney is going to also recommend you have what's called a pour-over will, which would be 1 or 2 pages, which is basically saying anything that I haven't put in my trust, I now pour over and put it in that trust at death. And many times that happens. People have a living trust, acquire an asset in their individual name, and they have to put it over into the trust, and they do that through a pour-over will. Most South Carolinians, I would say, if we look at item 2, and I know Jamie has forwarded you these different documents, is that you could do a will, and then inside the will have a trust. The will, of course, you have to be 18 years of age at least, or in sound mind. Basically know the object of your affection, know who you want to leave it to, and generally know what you own. The beauty of the trust is it protects those who cannot protect themselves from spending all the money. Good example is a child. If we have an intestate estate and it goes to a child at age 18, they can get the money out of the conservatorship. And so that's why it's important to have that trust. It acts as a vehicle or corporation, and what it does is it holds the money until you determine what age they should get it. Many times we'd recommend 1/3 at 25, 1/3 at 30, and 1/3 at say 35, so they learn along the way. Of course, with the right to invade for medical or healthcare reasons or for educational needs. I saw one trust, the young lady couldn't get the property until age 65. I thought that was a little bit late, but I think the parents were waiting until Social Security kicked in to make sure that they were protected. So if we don't have a will, the state legislature has written us a will called the intestacy statute, and basically your property goes according to your family tree. So we want to eliminate that, get with our attorney, and get a will done. And I'll show you a little bit later how to select an attorney. The third document, to avoid the conservatorship, you can use a trust, living trust, or you can use a financial or business power of attorney. And this is a document I can give to my wife, Michelle, and she can pay the bills if I'm incapacitated for some reason. Had a lot of kidney stones, so she can pay the bills while I'm in the hospital. Again, the power of attorney to be effective, the business one has to be recorded at a register of deeds office. So that's the financial or business, and that, like the will, are unique. You can put different powers in there. So you have to read each one of those closely as to what is granted in the power of attorney or what is left to whom in the will. Okay. Let me see that on question. Question is, if you've got a will, well, let's first back up. A power of attorney is only good during a lifetime. So once somebody passes, then the will would control. So if you're an agent under power of attorney, you can only act as long as the principal is still alive. Question is, how does the court ensure the legal will is read upon the death if a person submits an alternative will? Generally, the latest will will revoke the previous wills. If we have more than one will, then what would occur, we'd have potentially a will contest case. And those usually are on two grounds. One is lack of testamentary capacity or undue influence. So if there's a later will that's produced, parties can challenge that will. We don't have as many as will contests as we used to. They've kind of gone away. The kids are waiting, or not waiting till mom or dad pass. They're trying to get the money earlier. So most of our litigation now is in the trust, in the powers of attorney, and over the joint account with right of survivorship. So, but anyway, hopefully that answers your question. If not, if you want to type further in the chat, I'll try to expound upon what I've just said. When we're talking about powers of attorney, we also have a healthcare power of attorney. And if you took it up and looked at it, the one that Jamie provided, you'll see that it's a form document. It's that way so that the healthcare workers, the doctors, the EMS, the nurses all see the same document. And the healthcare power of attorney allows us to designate an agent to make healthcare decisions for us when we cannot. It does not have to be recorded. And again, it's a statutory form right out of our code of laws. So it's the same for everybody in South Carolina to help our healthcare workers. And you have a number of options there, from maximum care to withdrawal care, to putting it in on your own words, to indicating organ donation. So there's a lot in that healthcare power of attorney. The next document, number 5, gets confused with the living trust. It's called a living will. In a living will, this deals with end of life. The living trust deals with property. Declaration of desire for natural death, as it's known here. Well, it was a case out in the Midwest. A young lady was involved in an automobile accident, ended up in a ditch where they had water, did not get oxygen to her brain. She indicated she did not want to be kept alive by heroic means. The hospitals are to do no harm and to save lives. So the case went all the way up to the U.S. Supreme Court. They said you could withdraw the life support, but it's such a step that you're taking that it needs to be in writing. So that's the need for the living will. And if you look at the living will, it also has flexibility. You can appoint somebody to enforce it, and you can appoint somebody to revoke it. Nutrition, hydration used to have to be provided. They can now be withdrawn. So take a look at that. Another national document, well, a national document that's come out is number 7 there, which is the 5 wishes. And the 5 wishes, all right, what are the 2 certainties in life? 2 certainties in life. I guess. Of course, that's death and taxes. We always talk about taxes and complain. This Aging with Dignity nonprofit out of Florida is advocating that Americans talk about death and dying. So they've come up with the 5 wishes document. You can Google that one. We provided a sample for you, but you can Google 5 wishes, and I think for $5 you can download it. But it's sort of a combination healthcare power of attorney and living will, along with when you really when you're hospital end of life. We have a couple of documents that are orders from doctors. The first is a do not resuscitate order, also known as a DNR. I lost a brother to cancer several years ago. He had a DNR. He knew the cancer was going to take him. And so what he did was have a DNR in case he had a heart attack. He could go ahead and pass. Number 9, physician's order for life-sustaining treatment, a PULSE or a MULSE as it's known in some other states. Similar to the 5 wishes DNR. Again, you're indicating what your wishes are at the end of life. The beauty of these advanced directives is that it takes that pressure off of your family from withdrawing the life support. So I'd strongly recommend getting with your attorney and deciding which documents best suit you. Some of them do overlap. The main thing there is that you can have all of them, but just make sure you are consistent in what you're choosing. Don't say maximum care one place and withdrawal care someone else. We'll see a slide shortly on organ donation, and you can do that in your 5 wishes. You can do that in your healthcare power of attorney, or there's some separate forms that this gift for life for South Carolina can assist you too. Safe cremation. More and more people are choosing cremation. James Jordan, Michael's Jordan, dad was killed in North Carolina, body dumped in a rural county in South Carolina. They didn't have the space to keep him, so they took a dental mold and then cremated him, and then realized later it was Michael Jordan's dad. Our state didn't have a law in place, and so our state, many states passed a safe cremation law. So if you're considering cremation, a couple of things you need to do. One, if you want cremation, go ahead and get with your funeral home director and do a pre-need authorization. Number 2 is to go ahead and put it in your estate planning documents, such as your 5 wishes or in your will. And then 3, if you don't all agree, or I mean, if you don't indicate that you want cremation, all of your family members will have to agree after you pass. So go ahead and do it in your planning part. Picture of my mom here. Always have somebody to advocate for you. She was in the hospital, terrible pain, couldn't get that controlled. Doctors told us that we had to let her pass. We convinced the hospitalist to let her mind was so sharp to get somebody in from the outside, and we had a specialist come, and she got an epidural and was able to live another full year. So here she made it to one of her grandson's wedding. So always have somebody to advocate for you, even though we're advocating for these advanced directives. I'll show you this. This man got, let's see if you like this. Give us a thumbs up or something. Man got run over by a steamroller. I don't know. Y'all tell me if that's bad. I can get rid of that one. If you want to help others, we have the Coastal Community Foundation, your churches, your universities, your charitable organizations. They can help you eliminate the administrative costs to set it up. The Coastal Community Foundation will take away that administrative cost if you want to do some planned giving, and you can have a self-directed charity under their umbrella. We're blessed with the Center for Heirs Property. It's now located up in North Charleston at the Opportunity Zone. Would strongly recommend if you have heirs property, it's getting with them, and they will help you probate the estates, or another way is to get clear title. They're a nonprofit. Actually, we're initially funded by a grant from the Coastal Community Foundation. They also do wills clinics, and they help families in a number of ways. If you're looking to hire an attorney, a free service is called Martindale Hubble. You can see the indication down there called Martindale. If you Google it, it'll come up. It'll list all the attorneys around the nation, a list of local attorneys. You can look at their peer rating, A being the highest. You can look at their academic credentials. You can see if they're located close to you. So better than TV in selecting an attorney is using this service, Martindale. Of course, like when you select a doctor or someone else, dentist, you always ask family and friends. I do the same thing. Find an attorney that practices in this area. If you couldn't afford an attorney, there's a couple services that can help. One is Charleston Pro Bono Legal Services. Another is South Carolina Legal Services. And then Charleston Legal Access. If you don't qualify for one of those two, on a sliding scale, they'll help, and they may charge on the sliding scale. I mentioned earlier organ donation. This Donate Life South Carolina is one place that has the various forms and information on organ donation. And generally the recipient bears the cost for getting the organ. We had this California couple over in Italy years ago, and their son was killed, and they donated his body and organs to others. The Italians really didn't have an organ donation program going, and through his the family generosity there, they have changed the culture there in Italy. Just briefly run through elder law, some things you should consider. And what I really want to show you is a website that'll help you with looking at Medicare, Medicaid, so on, and knowing the differences and what you may qualify for and what coverage best suits you. And what Medicaid is, and whether long-term care insurance suits you. And that's the Palmetto Project. They're a free service. They'll actually come out to your home, and they have specialists that can help you navigating health insurance, Medicare, and Medicaid. So strongly recommend you looking at the Palmetto Project. We also now have a cabinet level department on aging. They also have a wealth of information to help our seniors. And then also the Trident Area Agency on Aging. They have a number of programs. I point out that family caregiver support. If you're taking care of an elderly family member, they'll give you a break. So look at that program. If you can't afford a bank to be your trustee, I'd strongly recommend Family Services. They're a nonprofit funded partially by United Way. A lot of the banks and trust departments, unless it's $1 million or $2 million, they don't want to mess many times with the trust. And I strongly recommend you take a ski vacation. Any skiers here? Let's see if we got any skiers here. Any skiers? And what am I talking about here? Oh, let me go back to the chat. Who is entitled to your personal property, house, boat, or if you are married, have adult children, and you don't designate who gets what in the will? First, we'd look at the will and see who it designates. Hopefully, you've got a clause at the end there called a residuary clause, and that's sort of a catch-all. So if you haven't designated who's going to take what, and it's a probate asset, then you can be controlled by that residuary clause. If it's not specified and there's not a residuary clause, or if it's an intestate estate, it would go according to your family tree. If there's just a surviving spouse gets everything. If there's a surviving spouse and children, any children, whether adult or younger, they would get 50%, and those children would share the other 50%. Nikki, I hope that answers your question. If not, type on. Okay. Anyway, ski vacation. What am I talking about here? Is we never know. Is spend the kids' inheritance. You never know when you're going to go, and so think about, may not be traveling, it could be traveling. It may be giving them a gift during their lifetime to see them, help them get a car, help with school, help them with a wedding or their first house. So consider a ski vacation. If not, if the kids are not good to you, you can also leave it to the dog or the cat. We now recognize Pet Trust in South Carolina, and happened about 3 years ago. And we had 2 dogs here in Charleston County. They got over $900,000 in trust. So not quite $1 million, but almost $1 million. They couldn't be kept outside on a chain. And then any surgery was down to the vet school at Auburn University. And then when the dogs passed, it goes to the SPCA. And we had another dog out on Kiowa get a home. So if your kids aren't nice to you, I always just remind them you might leave it to the dog or the cat. Hopefully they'll come around. Let's talk a little bit about wills, probate, and particularly estate administration. I know we have some people joining us who may have lost someone, or if you're doing your estate planning, you may have questions. You know, after I pass, what happens? If it's a summary proceeding, that's if it's under $25,000 in personal property and no real estate, you open and close the estate 30 days after a person has passed. Many times people have very wealthy estates, but everything's in a trust, revocable trust, but they buy one asset and don't put it in the trust, put it in their individual name. And so then it goes you'll have to go through probate court and they can use this summary proceeding. Most South Carolinians are fine going through what we call normal administration. Again, it's an informal process where you give notice to what we call interested persons. Interested persons would be those people named in a will called a devisee, or somebody who would take, if there's not a will, called an heir, and then also creditors. So we give notice to those. If no one objects, then it goes through administratively and we simply close it. There's a number of documents you have to file, and we'll take a look at some of those here shortly. Contested cases, I mentioned earlier, it's fewer cases, takes up more of the judge's time. We have notice and hearing each step of the way. But you can move from our summary proceeding, then realize you have real estate, go to normal, and then back over to contested, if it's contested case. But most of our cases, probably 95 to 96% are normal administration with no issues. Then and now, you used to have to probate your estate in person. We now have e-filing, and for one $7 fee, you can e-file anywhere in the world. Jamie here, my assistant, she's working on North Korea. It's the only place we haven't been able to get into. So if you have the scanner at home, or if you got a smartphone, you can probate from there. If you don't have those documents, then you can go to the local library. We've set up there, or you can come down to the courthouse. And our marriage license program is called this live online virtual e-marriage application. And so you don't have to come down now. We do close to 7,000 marriage licenses now each year. Anyway, you thought they're talking about nuclear weapons, they're actually talking about easy filing. So we hope to get into North Korea. The point is, you can be anywhere in the world basically and probate your state in Charleston County. So we're very accessible. There is a one-time $7 fee. Nothing's ever free, but this is close to free. And you just pay that once, and you can file as many documents as often as you want on that one particular case. And when you consider your postage, or if you consider driving down here and paying the park, you're well ahead of the game by doing the easy filing. We'd recommend using a courier service or delivering the will down here, not using the regular mail to get us an original will. And again, if you're anywhere in Charleston County, I would advise you to go to our local libraries. They've all been redone. They're gorgeous inside, and they also are set up for our easy filing system. And so you can, like I am here demonstrating, be at a local library. This is in North Charleston, and I'm using a scanner and can scan at no charge, and except for that one initial $7 charge, scan and probate your estate from a local library. What are we seeing coming through the court? We lost the Charleston 9. I grew up with Randy and Billy Hutchinson over there on the playground. We found that many of the first responders thought it was bad luck to have a will. And so we've worked hard to make sure that they have their estate planning in order. They thought it was bad luck to have a will, so we need to make sure they have one. They're the ones running into the burning building, and we're running out. The Emanuel and I were murdered. They showed us that love conquers hate. We didn't have violence after that. I was honored to do a workshop, probate workshop for the families about 10 days after that tragedy at the main library there in the conference room and walk them through it. Reverend Clemente Pinckney there in the middle. He was instrumental in getting that right of first refusal so that if an heir is selling their property, the other heirs have a right to buy first. Just finished football. The Matthews family, he's the boxing coach at the Citadel. They reformed their trust. And so we helped them there. My son's always trying to collect autographs. I told him they needed my autograph that day. So Mr. Pickard won the Masters, the street over in James Island named after him. Very important that you tell your lawyer everything in your family. He had lost a son who came to watch him in a golf tournament in a car accident. He did not list the son in his estate planning documents, and we had to do trust interpretation that he wanted the children of the predeceased son to receive a share. If you're famous, your will stay with the court. Sheila Joe Jackson case showed us that. He allegedly threw a World Series, didn't sign many documents, did sign his will, and that went up. The residuary beneficiary wanted the original back, so they sued the probate judge up there in Greenville County to get the original. Went up to the state Supreme Court, and they said documents filed with the court stay with the court. So Countess started Spoleto, used a local attorney. And you can name your trust anything. He named it James Brown named it the I Feel Good Trust. So whatever, you can be very creative there. Marriage license, I'll run through these. If you got a family member getting married. And again, we have Love Form, which is the live online virtual marriage application. There's a 24-hour waiting period, but they can apply anywhere. The license is good only in South Carolina. Jamie threw this one in here. So it begins. I didn't like the tone of your ID. So it's less expensive to get married than divorced. The marriage license is only $70. To file for divorce is $150. So hopefully people will stay in their marriage. Who's coming through probate court? You may recognize Dr. Gupta. This movie stars coming through. Everybody's coming to Charleston. Everybody's coming to Charleston to get married. So, and we're here to help them. I thought I lost it there for a second. Let's talk about another area that affects all of our families, and that's mental illness and also alcohol and drugs. And we have a process called civil commitment. Basically, there's three ways to get into treatment. One is to go voluntarily. You can go to our local mental health center, or you can go to the Charleston Center, our local alcohol and drug. We hope you'll do that, or you can encourage a family member to do it. The other way is the civil commitment process, and it's an involuntary process. A family member may, or a professional may run across somebody that has a mental illness or alcohol or drug problem, and they fill out commitment papers. And we do commitments at the local hospitals. We're blessed with 3, MUSC, Palmetto, and the VA Center. Again, it affects all of our families. We've had some high-profile cases come through, and we just want people to get the help that they need. And again, the mental health is set up in one structure under state government. We got Centers for Mental Health, and then alcohol and drug is a separate state agency, also known as the Department of Alcohol and Other Drug Abuse Services, DAODAS. Our local one is called the Charleston Center, and it just recently reopened up there on Rivers Avenue. We have the Ralph Johnson VA Medical Center, And we're blessed. Any veterans here today? We have coins. We can send you a coin. But we appreciate your service. Ralph Johnson was a Charleston private, gave up his life saving others by jumping on a grenade in Vietnam. I want to talk just a second about what's happening in our community. We have a terrible overdose problem, particularly with fentanyl. And there's a way to stop or reverse some of those. And then also for our seniors, we want also them to be trained on this Narcan. It's a life-saving drug, and it's really just like a nasal spray. You can't harm anybody when you do the nasal spray, but you may be able to save their lives. So it might be an accidental overdose for a senior taking too much of the wrong medicine. So we'd want everyone to be trained on Narcan. And I did that, and they'll actually give you a certificate completing that. Nancy Stedman Shipman lost her son to a drug overdose and has been very instrumental in trying to help others through this overdose prevention. Again, the involuntary commitment process has a process there. If somebody's a danger to self or others, somebody can send out papers. I won't bore you with the papers today. We use those primarily for when we train police officers. Anyway, the involuntary commitment process, there is due process. The alleged the patient is appointed an attorney, guardian ad litem, attorney looking after their legal rights, guardian ad litem, their best interest, court hearing, and the judge tries to give them the best treatment in the least restrictive setting. Again, we hope people go voluntarily. If not, we had that civil commitment process. If they get involved in the criminal justice system, then I have 4 problem-solving courts. We've got the adult drug court, started in Miami. Judge Goldstein, the late Judge Goldstein, was a retired Brooklyn cop turned lawyer turned judge and started the first drug court. That's a year-long program, and we use incentives and sanctions to change behavior. We're not there to punish. Usually there's time hanging over a person, 3, 5, or 10 years. If they fail out of the program, then they just go ahead and do that, do their time. Okay, well, miss you, Keith. Just to let you know, we do have these recorded. If you can't sleep at night, you can watch me. We don't provide the popcorn, but we do have some recorded on our website, and you can come back to them. I went out to Seattle, brought back mental health court. I think I was out there before Boeing came to Charleston. They had lost a retired fireman and to a civil commitment patient. And so we're trying to use the tools of drug court on our civil commitments. For our veterans, we team up with the local VA to give our veterans the help they deserve. Judge Russell out of Buffalo started the first one. He was like me, not a veteran. I wish I was. But anyway, we've got a veteran judge running our veterans treatment court. They go through, again, like I said, most of them a year-long program. We use one incentive is a commencement and a graduation. They also have to pay restitution back. And as you can see, here's Chief Mullen, who was the chief of police at Charleston. He's now up at Clemson. But you'll see that Brian here is paying restitution back. What's the one house you probably should not break into? And that was the police chief's house. I don't know why Brian broke into that, but he did. That's what happens when you're high on drugs and alcohol. Anyway, he paid the chief back restitution. Brian's doing well, and the chief was a big supporter. On the far left there, if you look, you'll see Judge Brucey Hendricks, a federal court judge that came over and then started a federal drug court. We're proud that we got recognized as a national model once by the American Bar Association. We do a visitors program checking on our adults under guardianship. And we were teaming up with Maricopa County as the 2 selected. I go over to the Charleston School of Law and train students on what we're looking to, the wellness check, make sure people need the help, get the help they need. We also have the National Center for State Courts. And we were recognized to do this rapid response conservatorship project. we were selected along with Wayne County. Here's something that if you take time, I would jot this down to smart911.com. It is a free service here in Charleston County. It allows you to give information to put in the data bank at 911. So if you do call 911, the first responder then can be informed of your medical history, your important contacts. Again, it's a free service, and it just may give information to help save your life if you have a medical emergency. Again, we do these workshops. If I can ever speak to a group that you have, glad to do that. Got another question in the chat. Let me see. What happens if your sibling executor does not go to probate court or take responsibility for splitting the estate? Now there are assets to sell and distribute, but no probate number, no employer ID number for the estate. What is the liability for the person who has to sell those assets? Initially, let's just talk about if you're appointed as the PR, personal representative. You have no personal liability unless you waste or misuse the estate assets. An estate, there's just sort of a time frame. If there is a will out there, you're supposed to deliver that will to the court within 30 days. It could be cited for misdemeanor. Hopefully, in the case that you're talking about, that the people have delivered the will to the court. You are under a fiduciary duty once you're appointed as personal representative to handle the estate and to work through that process. Next question is, should everyone have a trust set up? I would say yes, but it's just a matter of where you place that trust and that trust document and how much you want to spend. The least expensive alternative is to incorporate it in your will, and that's called a testamentary trust. So if it does go to an incapacitated adult, or if it goes to a minor, then the trust can protect the person, okay, and manage the property. The other way is to put it in a revocable living trust. This is more expensive to set up, and you have to change all of your titles to the trust name. Other questions, comments? And again, we do the free workshops, and we're here to help you. I don't know if I answered your question. Okay. I got another question. It's a follow-up to my previous question. How do you spell the name of the clause in a will that stipulates who gets your personal property? Let's go through the different clauses. The first would just be a specific devise, and that's spelled D-E-V-I-S-E. And so you can have specific devises of cars, real estate, personal property, anything. And then every will should also have what's called a residuary clause, the final clause that just catches everything in case you missed something earlier. I would also point out that in South Carolina, you can have a written memorandum that allows you to change it without having to change your will. So your will is going to say, I may leave a written memorandum that handles my personal property. It can't be real estate. It can't be cash or anything. But if you've got fishing rods, jewelry, you can incorporate a written memorandum, and then that way you don't have to go to the attorney each time you change who's going to receive what. I hope that helps some. You'll also see the term bequest. Bequest in the older law meant personal property, and devise meant real estate. It now is devise is all encompassing, includes both personal property and real. All right, good. I got some other good questions coming in here. Does a durable power of attorney have to be filed at the court? No, a durable power of attorney is recorded at the Register of Deeds office to be effective. Again, a durable power of attorney, business one, is effective only during your lifetime. The healthcare one, it does not have to be recorded. If you're the only child and your father dies without a will and he is married, do we each get 50%? I generally would say yes, of the probate property. Doesn't necessarily mean if there's non-probate property. So if there's a life insurance policy that designates some third party to receive it, they receive that policy. Hope that answers that question. Should a senior use an elder care attorney? I would say yes, elder law attorney. And I would, the best way to choose is by talking to friends and family, and then also looking at Martindale. If you have a will with 2 witnesses done through an attorney in another state, is it necessary to make a new will after moving to South Carolina? It may not be necessary to do a new one, but it definitely is necessary, and highly recommend that you do a new one. The will from the other state would be accepted for probate here. Our laws are a little bit different, so you want to go ahead and have the attorney, local attorney, review it. I would also say that Mother's Day, Father's Day coming up, kids can pay for your estate planning, and the duty of the attorney is still to you. It's always advisable to have a South Carolina attorney look over your documents, particularly if you're a permanent resident here. If you have real estate property in a revocable trust, does real estate have to have appraisal done after death? Even with a regular probate process, appraisal is not required. If it's real estate in a trust, you may want to, for tax reasons, go ahead and get an appraisal, or for valuations, get an appraisal. I would consult your attorney, your CPA on that. Hopefully that helps. Did I answer all those questions? The one time the federal government is good to you is at death. They give you a free step-up basis. And let me try to explain that. You get, if I bought a piece of property 30 years ago for $10,000 and it's worth $100,000 today, if I sell it for the $100,000, I have a $90,000 income tax gain. If it goes through my estate and it's sold the next day for the $100,000, my wife would get a step up in basis of $100,000 to the $100,000. That's quickly a little tidbit there. I don't know if you got questions on that. All right, here's some of my ski vacations. I'm a Red Sox fan, St. Andrews. I don't know how they got me up on this horse. I'm scared of horse and heights. My wife there, Michelle, in Gum Alley in Seattle. And we went to the Olympic trials. I've never seen somebody so happy for finishing third. Anna Cockrell to the right there. Top 3 went to the Olympics, so that's why she was happy at the Olympic trials. And this past year we went over to Ireland. There's a heart attack on a plate there, and it's her breakfast. And we presented them a James Hoban portrait to the Irish Parliament. Guess what they have 2 of in the Irish Parliament? They're known for what? Guinness. They have 2 pubs in the Irish Parliament, so maybe that's why they get along a lot better. I can talk about a state process. Let me ask, there's got to be more questions. We can unmute. Sometimes that's easier if you want to unmute and any questions? If not, I'm back to the probate process and I can run through that. You tell me how everybody's doing on time. Everybody okay?
Yes. What is the process if you're having to have to be the personal representative of an estate? What's the process if you have to present documentations for that hearing? Is there a process to that?
Yeah, I mean, do you have a hearing coming up, or are you just trying to open the estate, or what process are you in?
I just opened the estate and
Yeah.
I request a formal hearing. So I just needed to know how do I, like, I have documents, it's like, do I do a form so I can submit the documents for the
Yep.
hearing, or do I just bring it at the hearing?
I would bring it to the hearing. You can submit it beforehand. Is there an issue with the appointment, or why do you need the hearing?
Well, it's just I have a renunciation on one, but I don't on the other. So I just feel comfortable having that individual go through a formal hearing to better understand the process of me being personal representative.
Okay. I can explain some of that tonight. What I might get you to do is just in the chat or to Miss Jamie Robinson is saying
Okay.
your information, and we'll give a call. We'll look at the file and give you a call on that. That might be the easiest thing to do.
She took it today, so she has it, and she
Miss
invited me
Robinson
on.
does? Okay,
Yes, she does. She invited me
okay.
on the chat for tonight.
Good,
Thank you.
good, good. Yeah, we'll take a look at it and get back to you. How about that?
Thank you.
Okay, sure, you're welcome. Anyway, here's a typical estate file, and I'll run through this. I know it's getting close to 7. I try to keep it to an hour or so. But we start with a death certificate. We run all the way through to a certificate of discharge or closing the estate. An example I have here, I've got dad passing, survived by mom and 4 kids. 2 kids are named in the will, 2 are not. And so we'll look at that as we go through. If you got specific questions on any of the documents, please put it in the chat or unmute and ask me. But it's if you can think of the probate process in South Carolina, it's an informal process. We give notice to everyone who are called interested persons. That's the heirs, the devisees, and the creditors. If no one objects, then it goes through administratively, and we simply close it thereafter. So I'll run through this quickly, and we can come back and focus on a specific question. Again, when I talked about death certificate, we need that. If you die with a will, it's called dying testate. Without a will, it's intestacy. If you don't have a residuary clause, we could have what we call a partial intestacy. I mean, we have a will, but nothing on top of that, or nothing that don't have the residuary clause that handles all the property. So part of it's intestate. We start the probate process by what we call an application. All right, let me see everybody raise their right hand. If they're sworn in as the personal representative, what are we looking for when people are sworn in? Oh, let me see. Okay. Not everybody's playing tonight. Got to unmute, or not unmute, but put on your camera. In the olden days, if you're dishonest, they'd take a red hot poker and send a mark in the palm of your right hand. I didn't see any tonight, but we had somebody take the stand one time and they had a mark in their hand. I had to ask him about it. He said he had a construction accident. Okay. Question is, does having a trust avoid having to go through probate? Yes. If the trust is outside the, if it's a revocable living trust and you put all your assets in there. Now that's the advantage. But I would say that the probate fees in South Carolina relatively small. It's $95 on the first $100,000 of assets. You'll look at the application here. Probate forms, we got hundreds of them, and they can be used. This is for an informal probate. We see it over there on the left. And if it's formal, it would be petition. We talked earlier about interested persons. This is where we see it in 4A. We've got mom and 2 kids that are named in the will. They're called heirs. And 4B, we've got 2 that would not take under the will, and they're called heirs. So the one above are called devisees. I'm sorry, but anyway, we'll show later where we give them notice. Yeah, we will have access to recording this presentation. Somebody asked, and I've got some of my other ones that I have recorded. So we have a number out there, and I'll get Jamie to put in the chat where you can locate that, the ones that we have recorded. I haven't told my bad jokes today, so y'all are spared. You have to watch that one for the bad jokes. Okay. All right, who's been in a courtroom before? Have I been in a courtroom? Let's see, yeah, we got some speeders on here tonight. Anyway, 2 rules with jokes in a courtroom. And one is what? Only the judge tells them. What's rule 2? Everybody has to laugh. So you have to laugh at them no matter how bad they are. Anyway, we're talking about the probate process. And oh, very good. Okay. Get my jokes. Okay. So we're giving notice to interested persons, deposees and heirs and creditors. But first we're doing this application. We'll deliver the original will to the court. If you had an amendment to the will, it could be called a codicil. You may reinstate the entire will except for, say, the appointment. You would verify the information if anybody's here out of state. Anybody here from Alaska tonight? Alaska, Hawaii. I'm still waiting for my first from Hawaii. Anybody overseas? Okay. Anyway, if you look at the verification there, it says you say the information is true, but you also hereby submits to the jurisdiction of the court in the state. So just keep that in mind if you're out of state. We would do an order of informal probate. That's for the will. Appointment is for the personal representative. Used to be called executor, executrix, now called a personal representative. And instead of being sworn in with raising our hand, we do it informally under this qualification and statement of acceptance. After you open the estate, you'll get 2 receipts, one to open the estate and then one for the publication. And then the creditor's notice, you would select which newspaper, and we'll see a sample of that. The creditor's notice runs once a week for 3 consecutive weeks. Bond, if you, another reason to have a will, you may have to post a fiduciary bond. This just covers in case it's an insurance policy that the personal representative will do what they were supposed to do. Great flexibility in the probate process. You can renounce your right to administer. You can nominate someone else, or you can wait and you can waive the bond. Once you're appointed, you get a certificate of appointment and also fiduciary letters. That's what you present to the court, not to the court, to the bank, to the brokerage firms, to let them know that you're in charge. Like a president's in charge of a corporation, you're the personal representative in charge of the estate. Again, we talked earlier about giving notice to the kids and to mom, and they do this through this called information to heirs and deposees. And then you let the court know that you've done that by filing a proof of delivery. Again, the time frame is 30 days after person's passed. You're supposed to deliver the will to the court, and then 30 days after your appointment, you are to send out the information to heirs and deposees. And then 90 days after your appointment, you're to do the inventory and appraisement, which we'll see shortly. And this is inventory and appraisement. We talked earlier about non-probate and probate assets, and probate are controlled by the will. That's the only ones you have to list, even though sometimes a non-probate can be much more valuable. And you'll see supporting schedules there. And you fill out the information behind it. And you work with your broker, work with your CPA to get the right values down. Again, some assets generally are non-probate, but can be probate, like life insurance, if it's payable to the estate. And you'll see these supporting schedules. You do not have to hire an appraiser unless you have, say, unique property, or if you've got valuation, if there's an issue over what something should be valued at, and it may impact what somebody else receives. Again, when you list the encumbrances, you don't have to list the unsecured credit card bills, only something that has a secured interest. Thank you, Jamie, for putting that in there. So if you can't sleep at night.
Quick question.
Sure.
How do you know how much surety bond you are supposed to have as a personal representative?
Good question. Yeah, good question. I should have answered that. The bond, personal surety is generally 1.5 times the value of the personal estate. It does not include the real estate unless the real estate is sold during the estate administration. So it's 1.5 times the value of the personal property. Right. You follow that? Yeah. Okay. But
Okay,
hopefully,
so if you don't have an appraisal, say the only thing you have is just real estate, but you don't have an appraisal yet, but you're just starting. So do you wait until you get the appraisal for the real estate to get the bond, or you just bond?
you may not need the bond. If it's just real estate, then you don't, the bond is not calculated on the real estate unless the
Okay,
real estate is sold. It's only on cash, marketable securities, things that can walk away. It's only on the
okay,
personal property.
thank you.
Couple other in the chat. How can heirs or devotees access funds while probate is in process for paying bills, such as other bills? Yeah, you can, everybody says it's tied up in probate. That's not the case. If you can come down and get appointed, once you're appointed, then you can access those accounts. You can pay bills. Funeral bill has the highest priority, so you don't have to worry about paying something too early. But if you don't have enough assets to pay all the different creditors, you may want to wait until the creditors period is expired and you know exactly what you owe and who you owe it to. Hopefully that answers your question. If not, type some more or unmute. Once the inventory appraisement is filed, you'll get a bill or a receipt, and you'll see there's only $95 on the first $100,000 of probate assets. And then we give you a receipt. Here's an example of the creditor's notice. This one's in the Moultrie News. It runs once a week for 3 consecutive weeks. And then the creditor's period expires 8 months from the first publication or 1 year from date of death, whatever is earlier. And here's an example of a creditor's claim. If you're the personal representative, then you can, 3 ways you can handle it. You could pay it if you think it's a valid claim. You could pay it, but say it needs to be compromised, that it's too much, or they're overcharging, or they've paid some, or 3, you could send a notice of disallowance. Attorneys argue everything. This attorney in Greenville had argued that there's a claim that was filed on a white sheet of paper. They argued that it should be on a pink sheet of paper. Our state Supreme Court said, no, it doesn't matter. So whatever color you use, even though I'm using different colors tonight, as long as it has what the statute requires, then you can, you'll be okay. And if you look at all of these forms, if you ever wanted to look at the law on the bottom left, you'll see code sections. And so you can go to our South Carolina probate code and see what applies to that. Again, for creditor's claim, we want to look at a paid check when it's been paid, or a notice of disallowance. Okay, that's being handled. And sometimes there might be an order for somebody file an action to allow the claim. These are just some of the forms related to claims. And then we probably issue an order allowing or disallowing the claim. The deed of distribution, let's talk a little bit about this. The way the personal representative gives up their title to the deed is by filing a deed of distribution. It's filed at the Register of Deeds office. It then is given to the court. We put a copy in the file and then send you a copy. To do the deed, it's done by the personal representative. Your property description. Again, an attorney has to do this, or you have to do it yourself. But work with an attorney is advisable. And then you complete it, you file it at the Register of Deeds office, or give it to us to file in the Register of Deeds office. And then once the stamped copy comes back, we put a copy in the file and then also send you. Jamie also put different links in the form. Again, to close the estate, we have 3 ways. 1, if you're the sole heir, sole devotee, you can do a verified statement. 2 is if standard closing is giving notice to everyone, and if nobody objects, then it's closed. And then the third way is everyone has to agree, and then they file waivers of getting the statutory closing documents. Anyway, here's a verified statement. You're the sole heir, sole devotee, surviving spouse, no kids. Who else you're going to give notice to? You give notice to yourself and the earlier creditor's notice. Again, before we get into all the documents, if you get the entire family to waive all the closing documents, that will suffice. And sometimes families do that because otherwise you're going to have to come along and for us do an accounting, disclosing information, who they paid, receipts and disbursements. And so they have to do a number of closing documents. One is the annual accounting. Two is a proposal for distribution. If you do give property away, you want at least a receipt. Hopefully you can get a receipt with a waiver. And so you can see hereby submits, forever discharges the personal representative. Sometimes people are leery, and most people should be leery on signing something that's a full release. Question is, do you have to open a state account to pay bills by check only? That generally is advisable to use a checking account. That is a textbook way to do it. I would say it just depends on the family circumstance. If it's a verified statement, if everybody's getting along, there might be other ways to do it. But textbook is to get a federal EI number and then also to open a separate estate checking account. That is the textbook way to do it. There are other ways to do it also, but you need to do those in good family situations. Again, there's the waiver. Jamie, we can take this one out. We got the earlier one, and we're updating our forms here. So you can waive all the documents that we just went through. Sometimes if it's 2 or 3 or 4, they'll do that. You also, when you send out the closing documents, you have a notice of right to demand a hearing. And this is an example of that. Basically, you say, I've done my job as personal representative. Here's what I've done, my accounting, my proposal. If you have any objections, you have 30 days to come forward. And here's an application for settlement. You'd send that also to the court. And at the end, you're going to send a note. This is the affidavit, proof of delivery. And you give notice. You can see at the end, it's just 2 of the kids. Earlier, it was 4 of the kids. Yeah, the EI number comes from the IRS. I believe they have a toll-free number that you can call. Jamie, I'm not sure if you've got that IRS number, but if you do, that would be helpful in the chat. And again, you'll get an order closing the estate. And always remember your estate planning and to take the ski vacation. I would mention if you close the estate and then you find additional assets, you can reopen it. And we're getting all these $30 and $40 refunds from Dominion. If you have unclaimed assets at the state treasurers, you can reopen the estate. You don't have to, it doesn't reopen the creditors period. There's another form to use. And for some reason, the fee to reopen is $22.50. I don't know how they came up with that, but that's what it is. Y'all must have some more questions. Feel free to unmute. And you'll see my direct dial number here, my cell, and my email. If I can ever help you, give us a call.
Good question. How long do individual have to, I guess, challenge an estate after it's closed?
You mean to challenge a will or to challenge?
Like the the personal representative done their job. Is there a statute of limitation for someone to say that they want to contest what the personal representative has done?
Yeah, they would do that. Remember when we're filing those closing documents, we're going to lay out what we did with the accounting and proposal for distribution. If somebody objected, then they can demand a hearing.
So even if you did the hearing and you closed out and you gave that personal representative, okay, they satisfactorily did, what probate says they've done, but say 3 years later, something else comes up. Is there a time frame with the time in which is closed that you could say, well, I found this to come back to probate? Is it like 20 years? Is it forever? Or is it closed once it's closed? Like, yeah.
It depends. It depends, and generally it's 1 year from date of death or 8 months from that first publication. And if it's been closed, it depends. You're not talking about a case here in Charleston County, are you? No. I think there was one just filed like that.
Oh, I'm sorry. No, I haven't done anything with it, but I was just wondering. I just thought that there was like a statute of limitation of like 10, 20 years before you
Well,
could
there are
just
some
say,
out
okay.
there. There are some out there. The first one you need to consider is that within 10 years, you need to probate the estate. And many times we have individuals that have a will and they haven't probated it. You have to probate it within 10 years, or it's considered that you died, person died intestate. So we can't probate that will. I had one that was 9 years and 9 months could take it. Another one was 10 years and a month, and I couldn't take that. So the statute of limitation is 10 years. As far as challenging, a creditor's claim, again, is 8 months from the first publication or 1 year from the date of death. And then you have other statute of limitations if it's something that arose after, say, when the personal representative was appointed. Does that help?
It does. Thank you.
Sure. Jamie, put the toll-free number in there. Thank you. Uh-oh. I lost my point. Now back to the begin. Other questions, concerns? Anything I can help you with? Jamie, I think I'm sleeping and I stayed up last night. We lost a basketball game that I coach. I don't sleep well after I lose a 8th grade championship game. But the better team won. That was the other team. Other questions, comments? We got the toll-free number in there. We've got a link to the other ones if you want to watch. Let's see. Y'all tell me if this is a good time. Generally. All right. I'm gonna get off the screen share and see what we got here. All right. Y'all been a good audience tonight. Jamie, anything I didn't cover tonight? I lost Jamie. Again, I do one of these about every 2 weeks. I do one at night, and then here comes Jamie back in. And I do one at night, 6 o'clock, and another one generally at 10 o'clock. Then if you go to our website, we're out at the local libraries and at the senior centers. And if you haven't been to a senior center or local library lately, I'd advise you to. It's amazing how good they're looking, particularly those libraries and senior centers. Jamie, is there anything else that I missed tonight you can think of? Uh-oh, I can't hear. Okay, audio's out on Jamie. Well, everybody have a good evening. If I can ever help you, give me a holler, give me an email or just anything. And let's take that ski vacation, get that Narcan training, and get our estate planning done and enjoy life. Never know when God's gonna call us. Good. Take care.
Thank
Bye-bye.
you.
You're welcome. Bye-bye.